Well, if you're 55 or approaching it, or if you know someone who is, you might find this segment most informative and very useful. For those of you at that stage of life, you may think it's too early to think about a will or other essential documents that many reserve for older age. Joanne Seminara is the first to tell you, big mistake. She's an elder care attorney who has written this handy guide, 5 at 55, the 5 essential legal documents you need at age 55. Good to have you with us. You write a book from a lot of experience. You've dealt with a lot of clients who just don't look at those essential things. Let's begin with one. What's the most important thing that you should know by the time you're 55, or do?
Well, we chose 55 as an age marker at which we want to educate people. This is the age at which you've got to start to think about putting agents in place to take care of your affairs if you become ill and unable to do so. It's also the age where you should think about having a will or a trust so you can tell the world who you want to leave your assets to, who should be in charge of managing your assets if you become too infirm to do that, and who will actually be your executor or your trustee when you pass on or become unable to handle your own affairs. The idea for 5 at 55 came out of a practice of many decades of seeing people come into our office without documents and being unable at that point in their life, maybe they're in their 90s or their 80s, maybe they have the beginning of dementia, which is rapidly on the rise in our society, and unable to articulate or think clearly about what their wishes are and put them to paper with a qualified attorney. Many times we see children of elders who are already very ill, who've had an emergency mishap, who are in a nursing home, who have the beginning of dementia, and they'll say, I need to plan for my mother. And I'll say, well, where's your mother? And they'll say, well, she's not really able to participate in this conversation. And I'll say, did you bring a power of attorney? I can't have a conversation with you about your mother's affairs unless you're her agent. And so we wrote this book because we want to educate people about the importance of planning before disaster strikes, before they become too infirm or under the influence of a disease that impedes their ability to plan, and to take the stress off their families so their families can help them at this time of need. You need to put agents in place to help you maintain your assets. If you have an emergency, you need to go to the hospital and you need to stay there or go to a nursing home, and you can't write checks out of your checkbook. Who's going to pay your rent?
So you need that power of attorney.
You need that power of attorney. You need to appoint an agent. You need to do it with the advice of a qualified attorney. More than half of the powers of attorney that I see drafted by attorneys that don't practice long-term care for long-term care need situations are not able to be used in terms of transferring assets to qualify for Medicaid or other long-term care benefits.
Now you need that health proxy.
The healthcare proxy, so a power of attorney is a document in which you appoint an agent to act for you with regard to your property. A healthcare proxy, which is one of my essential documents, is a document in which you can appoint an agent to make healthcare decisions for you if you cannot make them for yourself. Not if you're competent, you can speak to your doctors and your healthcare providers, but if you take ill, you're in surgery, a decision has to be made, you're in a coma, whether it's temporary or permanent, or you have dementia and decisions have to be made about your care, where you should be cared for, who should care for you. And the healthcare agent will now have that document to show the world, to show the hospital, the doctors, I'm in charge. And without that document, you have issues within families about whether it's Johnny or Mary or Susan. Well, who's in charge? Is Dad in charge? Is the second marriage husband in charge? And I've had those people at my table in times of deep distress when their loved one is in pain and no one is making those decisions, and we're having a conversation about who's in charge.
Now, you point out in the book about, as far as a will,
yes.
If you have no immediate family and you don't have a will and you have assets when you pass on, that could go to your 18th cousin who I haven't seen in 50 years, as long as it's a blood relative, correct?
Well, it's not quite the 18th, but if you don't make a will and tell the world who is going to take your assets upon your death, the state of New York, you'll go to the law and you'll see what the menu of people that are going to get your assets depending on who you have left. So if you have no siblings and you have no parents, you have no children, and so now we're looking to your cousins. and maybe you haven't seen one of your cousins in 30 years, and that person is now going to be your heir under the state of New York. So you want to make a will to set forth who will take your assets and who's going to be in charge of making sure what is in your will actually happens.
You tell an interesting story here about someone who had his mother in a house, if I have the story correct,
Yes.
and then he passed on, and the daughter-in-law sold the house from under the mother.
So the problem we see is people read a lot on the internet, or they hear things from their friends and relatives, and they think they can do their own planning. So they say, I know what I need to do. I need to take my house and transfer it to my children. So they go down the street and they say to attorney, I want to transfer my real estate to my children. Without the comprehensive advice that we give our attorneys in terms of how to do things the best way, I met a person in a nursing home. She actually wasn't my client. She whispered to me in the hallway, I've got to tell you what happened to me. I'm being evicted from my home. I said, wait, what happened? I transferred the house to my son. I thought that was the right thing to do because my husband has dementia. He's going to need long-term care. So the son owns the house. The son passed away, and his next of kin was his wife. He had a will leaving everything to his wife. And so the wife inherited the home that the parents belonged to the parents, and now she didn't get along with her mother-in-law, and she was evicting her mother-in-law from her own home. No planning.
Another bit of important advice you give
Yes.
in the limited time we have as a nursing home, Medicare pays for it if you have no assets. So you can't do that planning and dispose of your assets the last minute. You suggest doing that earlier.
So that program is called Medicaid, and it provides for long-term care needs, not medical skilled care needs. And in order to qualify for that, you have to have less than a certain amount of money. It's around $15,000. And if you don't plan far enough in advance, you will have a penalty in terms of accessing that care.
Lots of good advice. Where can they obtain this book?
Well, lots of bookstores have it, but it's also on Amazon. Our goal was to educate people about the need. It's full of stories written in lay language about why you need these documents and the importance of having them and the disasters that happen that we have seen when you don't have them.
Joanne Seminara, thank you so much
My
for
pleasure.
your guidance. Something to look at carefully.
Great.
Thank you.
Thank you.
And that'll do it for our program for this week. If you have any comments and wish to see this broadcast again, log on to our website at pix11.com/newscloseup. I'm Marvin Scott. Thanks so much for joining us. Enjoy the rest of your Sunday, everyone.